All rise. The District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Patricia J. Kelly, Judge presiding. Those having business before the court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. You may be seated.
Good morning, everyone, and welcome. For those of you who are not familiar with our procedures for oral argument, the appellant goes first. You get to reserve 20 minutes. You have 20 minutes. Each side has 20 minutes. You get to reserve, I've only said this 100 times. You get to reserve 5 minutes for rebuttal if you're the appellant, and I can keep track of your time for you and let you know when you're at your 5 minutes. So our first case this morning is Delgado versus State. Whenever you're ready, counsel.
Thank you. May it please the court. Members of the court, my name is Jervis Wes, and I represent the appellant Israel Delgado. And before I begin, I'd like to reserve 5 minutes for rebuttal.
All right.
And members of the court, unless the court would like me to address a specific issue first, I would start with the first issue and go in the order listed in the briefs. The first error that the trial court made in this case was to admit the child hearsay statements. I believe they were a critical portion of the state's case.
Would you do me a favor? Would you talk into the mic a little bit more?
Yes. The error that the trial court made in admitting those statements was essentially employing the wrong analysis. Under the Townsend case, the Florida Supreme Court made clear that this is evidence that must, before it can be admitted, it must have clear indications of reliability. And they even used the phrase, it must be clearly reliable.
I'm with Judge Valenti. I need just a little louder.
Oh, I'm sorry. In the Townsend case, the Florida Supreme Court made clear that before child hearsay can be admitted, a trial court must find that it's clearly reliable. And given also that it's hearsay, it comes to the court with a presumption that it's not admissible. And that the evidence code clearly states as such. And that makes it very different than, for instance, the evidence in issue 2. So in this case, the trial court essentially viewed this as a presumption that the evidence would be admissible. And the court essentially recognized that there were indications of reliability throughout the statements.
Did you run a motion in limine first, test the admissibility before the judge had to rule on this during the trial?
No, Your Honor. It was, I was not the trial attorney, but I'm about 99% sure that it was raised beforehand. It was raised beforehand.
In limine or just?
In limine, it was, I believe it was even a couple of months before the trial started. And I can double check.
Motion to use child hearsay, kind of one of those things you have a hearing on it.
Exactly, and
It has to stand alone.
it was, and if I recall, the judge, I don't know if the judge entered a written order, but I know gave a pretty lengthy oral order at least. And I believe, thinking back, that it may have been the state's motion. I believe the state may have had the onus to file that motion and address it before the trial, but it was addressed before the trial. And the trial court gave a pretty lengthy analysis of the statement, but again, the problem with the court's analysis is it's recognizing all these points where, yeah, there are questions about the reliability, but the court finds on the whole that it's not entirely unreliable. And the problem is that goes against Townsend and the presumption against the admissibility of hearsay. The court noted at several points that there were times when the girl making the statement doesn't give clear answers, essentially goes off on tangents, can't provide details. And the court, instead of following Townsend and finding that, yeah, these are indications this is not clearly reliable, essentially says it appears that there's some questions, but it's not entirely unreliable. And the court essentially flipped the Townsend analysis on its head and made a finding that despite all of these many indications that raise questions as to the reliability of the child making the statement. Again, 15, not a young, particularly young child, a child that you would expect would be able to relay these various details, especially given her accusations of how many times these acts occur. So in any event, I would suggest that the court's analysis in admitting that statement was flawed to begin with, and when we look at the whole facts of the statement, the totality of the circumstances, it would not be admissible under the child hearsay exception. And the higher case, which we rely on, I know the state pointed out, was not necessarily a case where the court found that the statement was inadmissible, but found that the court did not follow the proper procedures in admitting it. But I think what's important and higher is the court noted that there were clear indications of unreliability, or at least there were indications that made it highly questionable. And I would suggest the facts at higher are remarkably similar to the facts at issue here. And if comparing the facts that the court addressed in higher, I think clearly shows that any reasonable jurist following Townsend properly would see that the statement was not reliable. And moving on to the second issue, which is the admission of the collateral acts
Can
testimony.
I ask you a question?
Yes, sir.
You're talking about other factors that the court may consider. My question is, under the case law, the court may consider these other factors, but is not required to consider those other factors? Is that true or false?
As under my understanding of Townsend in the case law, there's a non-exhaustive list of factors that the court may consider. But I don't know that there's, I think it's probably in the court's discretion to weigh various factors and then potentially assign them different
Well,
weight.
one factor could be worth 5 other factors. Just like a death case.
I agree, it could be. But I think the going back to the Townsend holding that it must be clearly reliable makes this very different than a situation, for instance, in the issue I'm about to get into, where there's a presumption that it would be admissible. That's not the case with the child hearsay. And I would suggest that a proper weighing of the factors would indicate that it was not reliable, sufficiently reliable to be admissible. As to the second issue, this goes back to somewhat similar analysis, but based on factors that the Florida Supreme Court set out in McLean, would suggest that a weighing of those factors in consideration of the most pertinent of those factors, which I would suggest would be the closeness in time of the collateral allegations and the presence or lack of intervening circumstances. Consideration of those factors indicates that the trial court erred in admitting that collateral acts evidence, which was also very critical to the state's case. These allegations that were admitted as collateral acts happened 2 decades prior. They were never reported. I don't believe there was never any explanation as to why these acts were reported. And the reporting comes up when the prior alleged victim's daughter is now making allegations. And they're being questioned by other family members. So clearly the mother has an incentive to fabricate this, especially after all these years. And I would suggest the most critical intervening circumstance
That was the
really.
part of your argument I didn't really understand. Why does the mom have an incentive to fabricate allegations? I just couldn't connect the dots based upon what your briefing said.
Yes, Your Honor. So the JT makes these allegations first to her mother, and then there are a series of family meetings. This is a very close-knit family. And then, in fact, several of the family members actually live on the same property. So they have a series of meetings, and several family members are questioning what JT is claiming. They're questioning the reliability or the veracity of what she's alleging. And that's when the mother, by my reading of the record, essentially steps in out of the blue and says, hey, this happened to me too 20 years ago. Never told anyone about this, but she steps in and first makes these allegations when people are questioning what her daughter is claiming. So I would suggest that's the motive for her to fabricate this, to try to back up her daughter when others are questioning what she's actually saying, what the daughter is saying.
Okay.
The other, I would suggest, most critical intervening factor that was before the trial court that suggests why this was unreliable and why it should not have been admitted is the mother allowed JT to essentially go to Mr. Delgado's house every day for years. They would go on vacations together without her. I mean, the mother is alleging these things happened to her many years before, but yet she would let her daughter be alone with the person who allegedly did these things time and time again for years. I would suggest that is a critical intervening circumstance that the trial court did not properly weigh, did not take into account. And I would suggest the consideration of that
Is
fact.
that an intervening circumstance, though, as the case law?
Well-
My understanding of what the case law finds as intervening circumstance is for example, the allegation comes up, there's a nasty divorce, right? And so now, yeah, there's all sorts of incentives and motives that can come into question, and it's a big life change, and people can legitimately question, hey, is this just being fabricated? I'm not following how what you're suggesting here would be an intervening circumstance.
I understand, Your Honor, and really it may be even more of the lack of intervening circumstances. That's one of the factors, presence or lack of intervening. But even however it may be viewed, I don't think McLean, similar to the child hearsay analysis, it does not limit the court to considering only the 4 factors listed. So even if it arguably does not qualify as an intervening factor or a lack of intervening factor, I think it's a critical circumstance that must be taken into account, because it just, quite frankly, makes no sense that the mother would have allowed her daughter to have this much contact for all these many years if what she's claiming really happened. So for those reasons, again, I would suggest that the trial court erred in admitting that pretty critical evidence. And I think that had it not been for that, the outcome of the case very likely would have been different. Moving on to the third issue that we've raised in the brief, which goes back to the one allegation involving the alleged victim, MB. This is a situation that I would suggest is somewhat unusual, but the state, for reasons I think unexplained, did not charge a material element of that allegation in the information. With regards to the charges involving JT, they included the lewd or lascivious language. With regards to MB, that's not there, it's absent. And under Figueroa, which this court decided several years back, this is a situation where even though this wasn't raised in the trial court, this is a fundamental flaw that did not charge a crime.
The title of the count that said lewd and lascivious, and it cites the statute.
It does.
I mean, maybe the reason why there's no argument below about this is because the defendant had sufficient notice that that count was charging him with that violation of that statute, right?
Well, he had a very experienced attorney. I would certainly hope that she was aware, but I think the big problem is, and what makes this situation different than, for instance, the Huckabee case or the Williams case that the state relies on, is that if we look at the body of the information, it does not charge a crime whatsoever. It charges intentionally touching of the breasts. That's not a crime. It can be, certainly, if it's done in a lewd and lascivious manner, but that's something that can happen by first responders, parents. Many people can have reason to conduct such touching, or it can even be incidental. What makes it a crime is when it's committed in a lewd or lascivious manner, and that wasn't charged. And I would suggest if it's enough to merely cite the statute, then it makes charging documents fewer. Because
well, and also the title lewd and lascivious, and it's in the title of the count.
It is, but the actual acts that make up the charge are not there. And if we look at what they're alleging, the acts, it's not a crime. And that's, again, what I think makes this very different than, for instance, Huckabee. The discrepancy was there was a change in the statute, I believe. And when it was charged, this was, I believe, DUI manslaughter involving an unborn child. There was a change, and at one point the statute criminalized the death of an unborn child, and then it changed the wording to viable fetus. So the discrepancy there was they used the wrong wording because of the change in the statute. But clearly, it was a crime, and they alleged the elements of the crime at the time that the statute would have been in effect. Williams, similarly, it's a discrepancy between charging an attempted burglary and a completed burglary. Clearly, both are crimes, and the court noted in both of those cases, crimes are charged in the information. In this case, what's charged is not actually a crime. And given, in addition, the fact that it charges an unspecified date over a 2-year period, I believe Mr. Delgado was prejudiced, but more importantly, he's charged with something that would not be criminal. And for those reasons, I would suggest that the trial court wasn't presented with the issue, but it was an issue of fundamental error because, as in Figueroa, there's a material element that's missing, and what is charged is not a crime at all. And finally, as to the fourth element, I recognize that the state, the standard review is in the state's favor. I would suggest, given that the evidence is viewed in the light most favorable to the state, I also recognize, as the state points out, that trial counsel was somewhat specific in the counts that she was making the judgment of acquittal for. But I would suggest, based on the totality of the evidence, that that no reasonable juror could have found that Mr. Delgado committed these crimes. I think that, again, going back to the time that passed, the unspecific nature of the allegations that were made by JT, and again, bringing in the collateral acts evidence that had transpired 2 decades prior and never been reported, and from a mother who allowed her child to continue to spend time with Mr. Delgado over and over again. So for those reasons, I would suggest this is that unusual situation where the facts would not support a guilty verdict in the event.
Thank you.
Thank you.
That was excellent timing.
That doesn't happen.
You did it right at like 14 minutes, 30 seconds. Counsel.
Good morning. May it please the court, counsel. My name is Kirsten Jensen on behalf of Appellee, State of Florida. Unless the court has any questions, I will just go ahead and address each issue in the manner that Mr. Wise brought them up. In issue 1, appellant argues that the trial court abused its discretion by admitting the statements JT made to the CPT interviewer. The court properly recognized that when doing this type of analysis, the focus is on the person to whom the statement is made, the CPT interviewer, and the manner in which the statement was made. The focus of most of appellant's arguments is that none of these women are to be believed. At this point, and as we all know, credibility is for the jury to decide. At this point in the game, which was brought, if it's not clear, this was brought forward to the court by the state's notice of its intent to use the child hearsay statement, and that's when they had the hearing on it. The court properly went through all of the factors in determining whether or not this was admissible under 90.80323. The court did point out that the child's statements that she did say probably, but the court also explained why, in its opinion, that this did not render the statements unreliable or inadmissible. This is a series of sexual abuse that happened between the times of 7 and 13. And no, the child could not remember specifically every single thing, every date, and what specifically would happen on that date. But that's not unreasonable when abuse is occurring over several years. The CPT interviewer explained that each child is different, that there is no ordinary way for a child to behave under these situations. Each child is different. The court's findings were not similar to, this case is not analogous to Hire. Hire did not deal with whether or not the statements were reliable. In that case, the trial court just failed to do any analysis at all. That's not what we have here. Under Townsend, the court did exactly what it was supposed to do. This cannot be considered an abuse of discretion. As far as the collateral crimes evidence, under 90.4042B, the defendant's commission of other crimes, wrongs, or acts of child molestation are admissible, and they can be admitted to corroborate the victim's testimony. And this case is very similar to McLean. And in fact, this case is even more compelling than McLean. And where in McLean, it was not a familial situation, here it is. In McLean, the incidences of sexual violence were actually different. These are the same exact types of violence that occurred. And also, they are the same age. This also shows a pattern. of violent behavior. So again, it can't be found that the court abused its discretion in this case. As far as issues 3 and 4, respectfully, the argument that the information is fundamentally defective, I think is a bit disingenuous. This argument was waived. It was not objected to below. And that is because Mr. Delgado knew exactly what he was being charged with. And it was alleged that he touched MB's breast in violation of the statute, lewd and lascivious molestation. And again, so he cannot prove prejudice. And then also with issue 4, the convictions do not amount to fundamental error. Defense counsel conceded that the state presented sufficient evidence to present all counts except count 3 to the jury. The judgment of acquittal was granted on that count. And the testimony of the witnesses, that's sufficient. If the court has no other questions or any questions, I'm here.
Thank you.
Okay.
Thank you.
Thank you. And to respond to some of the state's arguments, starting first with issue 1, one of the statements that was just made was that this wasn't an issue where JT just merely forgot to remember every specific detail. I would suggest this is a far different scenario. This is a situation where even the trial court recognized she repeatedly is being asked direct questions, is giving answers such as probably, or is not answering the question that's being asked, going off on tangents. And
I just have one question I wanted to ask you about the first issue. And looking at it from a perspective of harmless error, like when you review her statement and you review her testimony, you know, if anything, even if there was an error, I find I'm having trouble seeing how it was harmful, because to me, if anything, it undermined her credibility. I don't find that it was very helpful to her.
in some ways, it could have undermined her credibility, and it's hard to say what the jury relied on, but it's a pretty critical statement that's coming in from a child victim years before the trial. And in a lot of ways, it's very corroborative of what she testifies to in the trial. So without knowing what the jury relied on, I think it's dangerous to assume it was harmless error, because I think that when it's particularly given the detail that the statement goes into and how long it is, I think that the jury may have said, well, she's saying she said these things before, they're consistent with what she's saying in trial, because to a large extent they are. There are some new things that come up during trial, but I think that the jury very well may have relied on what she said to the CBT investigator, and it is a pretty emotionally charged statement. And given that there are some discrepancies between the two statements, and there are some details that are left out, the jury, given the emotionally charged nature of it, and seeing a video, that may have glossed over.
Thank you.
And one other critical point that I haven't gotten into that I think is important for the court to consider is when JT is being asked to describe Mr. Delgado's body, and she initially says, I don't want to do that. And then, despite claiming to have seen him naked all these times, does not mention these large scars that he has from surgeries, does not mention that he only has one testicle because of testicular cancer, does not mention that he's uncircumcised, and that doesn't come up until the defense has disclosed a picture to the state, and apparently the state had asked if she knows the difference between the two. So those, I think, are pretty significant observations that the trial court overlooked in determining the reliability. Jumping ahead to issue 3, I know the state has argued again today that the issue was waived. And again, going back to Figueroa, I would suggest because a material element is being left out, this is not something that can be waived. And Huckabee, where the court found there was a waiver, I believe it was the first DCA, again, was the situation where it was viable fetus versus unborn child, but in both situations, the crime was charged. I would suggest under Figueroa, when we have this situation where the information does not charge a crime, it's not something that can be waived, and it's fundamental error. I expect I'm probably at the end of my time. Thank you.
Thank you. Thank you both.
Thank you.
Right, next up, we've got Bergman versus Tower Hill Select.
Mark Nation on behalf of the appellants. I'm going to address just the 4 issues on this proposal for settlement. I'll go through. Obviously, welcome any questions. Issue number 1 is the indemnification issue. The proposal for settlement itself had a requirement that my clients indemnify each other. There were 2 proposals for settlement, each of them for $501. Each of them required if they offered was accepted, to indemnify against any other person with an insurable interest in the money. That's in the proposal itself. The release said that they were agreeing to hold harmless and indemnify all claims a third party alleges a right, where a third party alleges a right to the money paid. Both of those required, if one of them accepted it, to indemnify for the continuing claim of the other insured. They try to make a distinction between the proposal and the release. 2 problems with that. One, it would make it more ambiguous if those 2 conflict. But the release itself would require if Mrs. Hartman accepted, and then Mr. Hartman continued along in litigation, and who they have a claim to each other's money, because the only money paid under the breach of contract count for the house would be to repair the house. They both had equal rights to that money. Yes, sir.
I understand your argument, and I get how you're constructing it and all that. It's really hard for me to get past the pragmatics of this, which is in what conceivable set of circumstances could you have it where husband and wife own the same property, it's the same claim, it's the same underlying event, it's the same, it's a one unified policy. It's going to be one payment on it. In what universe could you have it where one's going to accept and the other isn't?
But we have that. That happens.
Yeah.
That does. Oh, yeah, absolutely.
Like in a divorce, or how
Oh, no, that is a situation where it is, but sometimes one of them takes it, and because the amount of, we get to the good faith issue in a minute, the amount of money, the one will take it and say yes, but there's no indemnification. They're allowed to do that in that circumstance. But here, they've got these non-monetary terms, which is obviously another issue, that prohibits it. They can't independently do that. Now you can make...
They can. It's just, it's not like the situation where it's an all for one for all,
joint offer.
joint offer, or even individual offers where you're saying this is going to be subject to the other side. So it's not that they can't do it, it's just what you're saying, it's a bad deal.
No, they won't, they have no idea what they're signing up for.
A bad deal.
Yeah, well then, it would be bad if
But
that's
there's
the
nothing
point.
in the terms of the offer that prohibits them from accepting independent of the other.
No, it's the case law that tells us that they have to be able to independently address those, Safe Point
But
versus Brown.
assuming there's no marital problem, and then you're telling me that like this happens like on a singular claim, singular property, where they're both the named insurers, one takes the money and the other says now.
And they'll make a reasonable offer with no indemnification language? Sure. Yeah. And they do those exclusive and non-exclusive, so you have fees and costs, and so you have various scenarios. But the indemnification is the problem here. On issue 1, They shouldn't be required to indemnify each other. They should be able to get out of the litigation.
Well, then that kind of segues to the next one, I'm sorry, jump right in.
Please, you're not, please. It's better this way.
Indemnification per se isn't a problem, at least according to the fourth and third DCAs, right? Because the Kush case says you can structure an offer in OJ so that one offeree has to indemnify the offeror for a claim against the offeror on the proceeds of the offer. The Safepoint versus Brown case out of the third DCA. It's a water intrusion case that involved indemnity as to proceeds.
So Krush only talks about ambiguity. That's it. And I agree, including that doesn't make it ambiguous. It's clear you're going to indemnify it. So the issue is you can't do the independent evaluation. And that argument was not made in Kush. Kush didn't talk about, it was only ambiguity, and that's all they dealt with. And then they start talking about punitive damages. And this issue isn't raised because sometimes you can make a proposal super clear. It's still invalid.
I mean, I get what you're saying, that the issue doesn't appear to have been, I mean, we don't know if it was raised or not. They just said that's silly. We're not gonna.
I don't think it was made. I mean, nothing even indicates.
We don't know. We can't pronounce it straight down the four corners of the opinion. But my problem is it is out there. It seems difficult to conceive that if indemnity was just per se beyond the pale in an offer of judgment, like you just can't do it. Seems like that would be such an important point that someone would have held that back.
Somebody has, the Supreme Court in their amendments in 2022, because of what we're doing here today and having done it so many times. What they said is we were going to bring our rule into alignment. And let's think about what that means. With the statute, what they're saying is, hey, like all of us, we made a mistake with the rule. The rule's too broad. What we want is an evaluation of monetary terms, and that's it. Let's look at the amount offered and the amount of the judgment, which makes it easier, and we're not doing this all the time. And so there is a way to do it. Just do that. The statute says it is an offer or demand for judgment. That's it. So if you're going to make an offer of a judgment, do it.
So you think that wipes the slate clean as to the bad faith aspect? You no longer include bad faith claims as part of an OJ?
They can include it, but it's invalid. It's extrinsic.
Okay, so I appreciate the candor. Your view then is that amendment indicates a clean sweep of all the case law before the bad faith claims, indemnity, all that.
It absolutely is telling us, here's what the statute is. We're going to bring our rule into alignment of that, and that is so that we will have only a comparison of the monetary terms, and that's it. And I think it's very smart to do that. So you offer a judgment. Here's your judgment, just like you went to trial in this case. Your judgment is for X number of dollars, and that's why it's saying offer of judgment or demand for judgment. And then that's your judgment. Well, what could have been resolved in that case? We do know that if you go to get a judgment in a first-party case, in your breach of contract action, if you win, you can then file a bad faith case. Barton tells us that if you resolve it with a proposal for settlement, you can also then file your bad faith case. I get that they would want to include that in a proposal for settlement. It's simply not valid. And it probably works in a number of cases where they make an offer, it's everything, somebody takes it, it's done. But that's not where we are now. Where we are now is it valid? And I don't think under bringing it into alignment, it's valid. And if the court were to affirm this, then that just continues this trend requiring this. We have a clean slate. The Supreme Court is saying we would bring it into alignment. The statute has never allowed it. So next is the extrinsic claims, and that's what I was going to argue on that. And only compare monetary terms. They say it in the opinion. That's a quote. That's it. That's all we should be doing. It's a math problem at that point, not checking and seeing if relying under oath. That's the next one. Is there a lie? Was this negotiated? This was not negotiated. Take it or leave it. You're required to sign this release, and then it says, we've negotiated this. That is not true. Final issue is the good faith issue. In the record, and I would encourage the court, on page 674 of our record, I filed a motion for rehearing. And that's the hearing on the motion for rehearing. Put into the record and told the court, I am telling the court on this good faith analysis on liability, the exact issue for which summary judgment was granted in this case. I have tried the verdict many times, and I have won summary judgment on this multiple times, and I have never lost it. This still remains the only case I've ever lost this issue on summary judgment. Therefore, in the analysis is, you got to look at the entire record on the good faith analysis. And I want to make a point. We're not saying, when we say good faith and bad faith, I want to be clear. The offer of the judgment has to be a good faith effort to resolve the case. It's not a prevailing party issue. Good faith offer to resolve the case. That's what it's got to be. And looking at that, there are two issues that you look at, and you have to review the entire record to address these two issues. A reasonable relationship to the claim damages. No, not even close. They didn't even try. $120,000 estimates. It's the only evidence in the case.
Right, but I mean, you got to compare it to what the policy covers.
Oh, it covers it. That's why this is the only time I ever lost this.
This was the case where the water intrusion never actually did anything inside the house. There's no damage to the property, just to the underlying, to the fill.
The structural fill, which is, I get jury instruction, I put this in the record. I win that issue, structural damage to the structural fill all the time at trial. Summary judgments on it, I put them in the record. I get jury instructions say structural fill is part of the dwelling. We've got multiple cases where that's happened. And so that issue, that goes to the second issue, which is a realistic assessment of liability. So if we're going to do a realistic assessment of liability, it isn't just, well, did you win? Because that's kind of where we are. Or did you lose? It's not that. Look at the entire record, and the only evidence in this record is that I've tried that issue multiple times, never lost it on summary judgment once, and this is the only time. And so we look at that $501 with some skepticism. The case law tells us you gotta look at it with skepticism. Look at the entire record. Is it good faith? What is the only evidence in this record? They didn't address the damages component. The second component is a realistic assessment of liability. And all they put in is, well, we won. They don't look at all the other evidence. And I can't, and think about this, how do I go to my client when I tell them, I've won this issue all the time, try it all the time and won. I think I've tried 30 of them, but we should settle for $501 in this one because we might lose. Not the purpose of the proposal for settlement. Back to a good faith effort to resolve it.
I'm not sure your notion of good faith jives with what the case law is saying, which is to say we should look at a lawyer's track record on other claims in other places. I'm not sure that that's exactly what the good faith component of this is.
It's
because you can have a nominal offer.
100%.
And that'd be good faith.
And it can be, but it's always looked at with skepticism. And then you look at, here's what we're told, look at the entire record. Not part of it, the entire record. And what is in this case? I'm in a very difficult position in a case like this, where I continually won the issue and continue to, as I tried it last week and won it. And then we have...
Scott, you keep talking about what you've done in other cases.
Yes.
Is that in our record?
Yeah, yes, it is. On page 674 of the record, in the motion for rehearing, put an affidavit in, put the other words in.
All right, I just want to make sure.
Yeah, and I feel, look, I don't want to sit up here and say, I know how it sounds. But when you have to look at the entire record, then that is obviously a component of it. Because the lawyer, whoever the lawyer is, has to go to the client and say, all right, this is the issue, structural fill, whatever. Here's my record on it. Haven't lost it. They're offering $501 under $120,000 claim. I can't tell you in good faith, you ought to settle it because we might lose. So the past record has to be considered.
And again, I think you managed to flip the hats here. I think the good faith, it has to be, is it the insurer that's acting in good faith from their point of view, not the lawyer who's counseling the client. I've never seen a case that talks about it from the, because here's the thing. Presumably, if you're still in business and you're doing well, you've won a fair amount of cases. You've done good. That's great. But I don't think that's where the law is focusing on for purposes of good faith. I think it's looking at the insurer. Is this based upon a reasonable insurer's assessment of the potential risk and exposure of the claim? And that may be $1 or it may be, $100,000, but I think that should be the perspective, not you counseling a client.
So the definition is good faith effort to resolve the case. And so it's not talking about their
But
acts.
who's the one that's issuing the offer? It's the insurer.
Right, but we look at the entire record.
Right.
So the good faith effort, is it a good faith effort to resolve the case? It wasn't, they didn't address issue 1, they only addressed issue 2. And,
Sir, I
Yes,
just want to let you know you're at 15 minutes.
okay. Let me see if there was anything.
You can use your time however you like.
That's all I have right now. Thank you.
Okay, all right.
Yep.
May it please the court. My name is Ryan Jones and I represent Tower Hill. We ask that the court affirm the trial court's decision to enforce Tower Hill's proposal for settlement. Doing so enforces the statute, it follows Florida Supreme Court decisions interpreting the statute, and it would be consistent with other decisions from this court. I'll highlight just 3 points, and in doing that, I'll be happy to answer any questions that the court may have. The first point that I want to address is with respect to the indemnification provision. What appellants are doing is analogizing to the provision in the Brown case. That provision specifically stated that there would be indemnification unless both plaintiffs accepted. So it essentially took away their ability to independently accept or reject. But that's not the same language that Tower Hill used in this case. Tower Hill's provision only requires indemnity if a third party makes a claim to the settlement proceeds. And I think that's very important, to the settlement proceeds. Because a
I'm
settlement...
not sure you can read it that way, and I'll tell you why. So I'm going over this because you've got kind of a two-part textual analysis here, which is look at the offer, which then incorporates the proposed release. I think we all agree indemnity is a non-monetary term.
Correct.
All right, which right away should raise a red flag that, hey, is this outside the offer of judgment such that we're doing a math comparison? Here's what you say. Plaintiff's department agrees that by accepting this proposed settlement, they are responsible for paying defense indemnity, blah, 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 with an insurable interest in the property that is the subject of this litigation as specifically stated in the release attached hereto as Exhibit A. You argue that the release is, you then read that in tandem with this to limit it to just the proceeds that the other person is receiving, which the third DCA held you could do, but the language in that actually said explicitly the proceeds that the other person is receiving. So you're going to indemnify if anybody explains these proceeds that I'm sending to the other person. Here, your incorporation of the exhibit actually as a matter of grammar only clarifies what the property that is the subject of the litigation is. In other words, you are, as I read this, plain and unambiguous, what you're saying is you, Blanche Hartman, are going to be responsible to indemnify for any claims against any and all lien holders, mortgagees, and any other person or entity with an insurable interest in the property, whatever that interest is, and the property that is described in the release attached as Exhibit A. And that's all the release does, it describes the property. Help me out with that.
Absolutely, Your Honor. So that provision specifically says, as set forth in the release attached here too, when we move on to the release and the indemnity provision of the release that further defines it, because the indemnity provision of the release specifically says any claim where a third party makes a claim.
So here's the thing, you didn't incorporate, you didn't actually say in the proposal for settlement, we hereby incorporate incorporate the terms of the release. Instead, what you did is you pointed to it, and you say, as specifically stated, which as a matter of grammar, the way you got this set up in the sentence, would only apply to the last antecedent, which is the insurable interest in the property that is the subject of this litigation. In other words, Exhibit A, the way you got this structure is just describing what the property in the litigation is.
Your Honor, I submit that it could probably have been phrased better, but that sentence that specifically refers to the indemnity provision in the release, those two can go together. And I don't think that it's just the insurable interest. But even if it is just the insurable interest, that's all we're worried about right here. Because we're not talking about a lien holder, we're not talking about a mortgagee. The only argument that counsel has made is that we're talking about another person, Mr. or Miss, whichever one doesn't accept, with an insurable interest. And that's the one that, under Your Honor's reading, is tied to the release. And the release then says that third party has to come back and make a claim to the settlement proceeds. So here, the settlement proceeds, Mr. and Miss do not have a claim to each other's proceeds. The reason for that is that they are just that, settlement proceeds. It's not a property right, it's not an indemnity payment under the policy. And I think both parties' briefs are very, very clear on that. Because the indemnity under the policy, Tower Hill's position is that it's $0. And plaintiff's position, appellant's position is that it's about $120,000. So there's no correlation to the settlement amount offered there. The basis for the settlement offer is a sum of money that Tower Hill was willing to offer to resolve a lawsuit that it viewed as meritless. And it's allowed to do that. We cited a number of cases in the brief that accept those.
Was there an negligence claim in that lawsuit?
In that particular lawsuit, no, Your Honor, there wasn't.
Was there an extra contractual claim in that lawsuit?
In that lawsuit, no, there wasn't, Your Honor.
So you're getting more out of the release than you would have gotten by just a straight cessation of the lawsuit, correct?
We are, but all of those claims are limited to those arising out of the same facts. And that is allowed under the case law that we have. And I know Your Honor brought up the Cush case during counsel's argument, and that specifically addresses that issue of what's extrinsic to the case and what is not. In Cush, it was a first-party property case that did include a release of bad faith and punitive damages. And the court analyzed those two together. Now, the reason that analysis applies to bad faith cases as well is because the only way you can get punitive damages is with a bad faith case. And what the court found is that it was not an extrinsic claim because the release specifically said those punitive damages arise out of the facts of this claim. And that's what Tower Hill's release here says with respect to the bad faith, the extra contractual, and negligence. They all have to arise out of the claim at issue. So for that reason, we can have them all encompassing. That's also supported, Judge, by the Florida Supreme Court's Nichols decision, which again says the key to evaluating these proposals is to avoid ambiguity, not breadth. So here, it's crystal clear that appellants would give up their breach claims, their bad faith claims, extra contractual, if there is a difference, and anything else arising out of this claim. That is a broad release, but that's been accepted, and that's what the Florida Supreme Court's Nichols decision tells us we can do. One other point that I want to address is with respect to the good faith aspect. Here, and Your Honor's questioning was I believe, directly on point, because the good faith analysis only applies when we're talking about the amount offered unless there is reason to believe that there is nominal liability. And nominal liability, what we have to look at is from the defendant's standpoint, if the defendant has a reason to believe its liability is limited. And here, we have a claim that was reported. The adjuster for Tower Hill saw no visible damage to the property. The adjuster asked the appellants if there was damage to the property, and they responded no. And then Tower Hill's engineer went out, inspected the property, and saw no damage. From all of those factors, that's a pretty strong indication that there's no damage to trigger coverage under the policy. And as a matter of fact, that's exactly what the trial judge entered summary judgment on. So from that standpoint, Tower Hill had every reason to believe that it had no liability. And that is why this is considered a quote-unquote good faith offer, because it does satisfy that standard. And I think, Your Honors, what this case ultimately comes down to is the judicial philosophy that is going to be applied to proposals for settlement. And what I mean by that is on one hand, we can look at a proposal and try to find the tiniest inconsistency and use that as an excuse to invalidate the proposal. Essentially, that's what appellants are arguing for. On the other hand, we can start with a premise that a proposal that complies with the rule and complies with the statute is valid unless there's some uncertainty in there that affects the decision on whether or not to accept it.
Or we can take up Judge Gerber's suggestion and the concurrence and start requiring people to flag perceived ambiguities at the time that they receive the offer or else to waive them.
Absolutely, and I think Judge Gerber made that statement twice, 10 years apart, if I remember correctly. But no such luck yet.
Pushed that line a couple times and got no bites yet.
No such luck yet. And what I'll submit, Judge, is that the philosophy applied by the Florida Supreme Court is the latter. It is to enforce these proposals for settlement. That's outlined in the Nichols case, and I'd submit that this court has recognized that and applied that. I know in the Carriall case, and Judge Valenti was on that panel, followed Nichols with that same philosophy. And in the Desidue case, Judge Lucas was on that panel as well, followed the same philosophy. That is what the court should do in this case as well. It gives effect to the statute, it encourages settlement, and it discourages meritless claims. That's everything the law should do. And for all those reasons, judges, we're asking the court to affirm. And unless the court has any further questions, we'll rest on our brief.
Thank you.
As to the first issue on the insurable interest in the indemnification, counsel has argued that it was only the homeowners. Well, we have a statute that defines insurable interest, 627.405. Insurable interest, that's in quotes, means actual, lawful, and substantial economic interest in the safety or preservation of the subject of the insurance. That could involve a lot of different people who have an insurable interest in it. There is a case where somebody had a car that they used, didn't know, they used it. That was an insurable interest. We don't know what it means. Bottom line is, the Supreme Court made it crystal clear in the 2022 amendments that they were bringing into alignment the rule with the statute, and now we should only be comparing monetary amounts. That's what the statute has always required. That's what it currently requires. The rule is in alignment with that. We're not doing that in this case. We haven't even tried to do it. And so, let me see if I think, Judge Lucas, you've made the point. They're getting more out of this release than they ever could have got in a judgment in this case. They just offered the judgment. That's accepted.
Well, your friend makes the point that, look, it's tethered to anything arising out of the lawsuit.
Yeah.
So it's not a blanket further release. It's just anything that could have been raised in this lawsuit but wasn't.
Yeah. It couldn't though. We couldn't bring it until we get a judgment of liability and damages. We can't bring the bad faith case till then.
Yeah, but that should stay. I mean, bad faith can be included in an offer judgment as part of a release, right?
No, I don't. It's extrinsic. I don't see how it's. I hear you. I know.
2022 amendment
Yep.
swept away all the past case law without sub silentio.
That are in disagreement with what the statute is in monetary terms. But we could not, even if we abated it, they said we could have abated it. If there was an offer of judgment, that still wouldn't have addressed the bad faith if it was abated. And that's all I have. Thank you. Thank you.
Thank you. Thank you both. All right, the next case this morning is Smith versus Lynn.
Good morning. 2 seconds. Vertically challenged, so I'll bring it down a little. Can your honors hear me? Okay.
Yes.
My name
I'll
is,
let you know.
okay, awesome, thank you. My name is Megan Powell. I'm here on behalf of the appellant Jesse Carl Smith, and may it please the court. We're here today to determine whether the sellers of a property adequately disclosed 2 conditions, 2 specific conditions of the property. One of them was the extent of a 2020 flood that occurred at the property, and one is the flood history, which includes that the property is a severe repetitive loss.
Let me just, I hate to just stop you right at the
That's
beginning,
okay.
but in thinking about your arguments, I get the non-disclosure of the flood history, like why that would be problematic. I'm not as clear about why the extent of the damage from the 2020 flood is problematic.
I can answer that from a conceptual standpoint and from a personal standpoint, which is, I don't know how many of you have had a flood at your house. It's traumatic, to say the least. And I think the fact that this 2020 flood occurred was disclosed. Obviously, it said that there was a flood in 2020, slight
There was
damage.
a flood.
Right. The problem is,
And all the damage was remediated.
so it said all the damage was remediated, so there's no lasting physical damage. I agree insofar as that's the truth, right?
Right.
However, the fact that the 2020 flood caused catastrophic as opposed to slight damage is an important factor for a buyer to know, especially when you view it in a light of, in addition to the 5 prior floods, because we've got 5 floods on record that required a flood insurance claim to be placed because the damage was so bad that an insurance claim needed to be placed. And then we've got the fact that your house could flood repeatedly at that amount. $33,000 of damage to the property, plus an unknown amount of full contents damage, is foreshadowing for the kind of flood that you might experience at the property. So, and I'm not suggesting that the seller should have said, oh, we experienced $33,000 worth of damages and we experienced full contents replacement. What I think would have been adequate under the seller's disclosure would have been to say there was a flood in 2020, insurance claim was placed. At that point, I think that representation would identify to the buyer that maybe there's some kind of an investigation that needs to take place and maybe they can ask for the insurance information. There was not even a notice that an insurance claim was placed.
Well, you knew it was a flood zone.
Certainly, yes, it's
And, because they got an estimate on flood insurance.
right.
If I'm understanding the record correctly, when the Lynches were looking at buying this property and they got the information that it was in a flood zone and they were looking at flood insurance, they also got the seller to provide them with the flood history.
Yes, this is because
They knew that that was something that was available. The Lynches knew this, and they knew that it was only available to the current property owner.
yes, correct.
But they did think to ask for it.
They actually didn't think on their own to ask for it. If the court looks at the information provided by Mr. Della Costa, which is what you're, so what happened was Mr. Della Costa assigned his insurance policy to the Lynches when they were the buyers. So their insurance company was provided the information that this is a severe repetitive loss, and then the realtor told the Lynches, and based on the email between the realtor and Mr. Della Costa, the Lynches became concerned after learning of this, after getting assigned the insurance policy. I know it's a little confusing, but if you look at Mr. Della Costa's email, which he swore to in an affidavit was an accurate representation of his memory, he explains that that's the version of the events, that he initially discloses the flood that occurred when he was at the property during a different tropical storm or hurricane. Then he assigns his insurance policy to the Lynches, and then they learn about this designation, the severe repetitive loss designation. They then say, hey, that concerns us. Realtor, find out more information. Realtor inquires with the insurance company, and they say, only the homeowner can get that. So they ask Mr. Della Costa to get the information from FEMA, which he does. And then he supplements and revises the seller's disclosure to include not only the flood history, which was not provided to Mr. Smith, but also a description of the pump system that was in place in the backyard that nobody ever told Mr. Smith about to mitigate the potential flood damage of these repetitive floods. So that's how the Lynches found out. I hope that answers the court's question.
Yeah, I think I understand.
Okay, so I want to go back to the 2 lenses that we're here under. We have the fact that we're arguing that not only the court shouldn't have granted summary judgment in favor of the Lynches, but also that the court should have granted summary judgment in favor of Mr. Smith because it was competing motions, cross
I've
motions.
got a quick question about kind of a legal
Sure.
area. So I'm not sure I read Johnson v. Davis as creating a standalone, independent cause of action. I don't think it does. The cause of action in Johnson was rescission. Here, you're suing, I think the flag y'all are flying under is fraud, is that correct?
No, so the fraud and the inducement is an alternative count.
Okay.
I've seen a lot of courts, so Johnson v. Davis, they call them Johnson v. Davis claims, but they typically arise under a breach of contract or a rescission because the Johnson versus Davis disclosure requirement is actually a creature of contract law. So it may be labeled as a Johnson versus Davis case, but really it's a breach of the contract which requires a full disclosure of the conditions.
Okay, so
Under
that's what we're, the fraud and inducement is the alternative.
Yes,
Breach of contract is what you're flying under. Because Johnson v. Davis doesn't purport to create an independent cause of action. It just says you can't caveat emptor out under these certain kind of scenarios.
correct. And it also provides the standard that we review these sellers' disclosures under to make sure that they were adequately done.
So that segues into what I'd like to hear your thoughts on. Usually, and I'll just call them Johnson v. Davis claims, even though that's not a standalone cause of action, but usually it's a situation where we see there's some material condition that affects the house or the property itself in some way. And that includes even in the case, I think it's the Revitz case.
Revitz versus Terrell.
Right, where there may not have been an actual physical condition, but it was built according to code. Right, so you could, like, literally, you had a code violation that you were buying into that it looked like the seller knew about. That's not really what we have here, because you're not suing because of any flood damage to the property. You're not even really suing because of the propensity to flood, because again, you knew it was in a flood zone, it's on the bay. Rather, you're suing solely on the discrete issue that flood insurance costs more than what we were anticipating. Have you found it? I mean, that's kind of how I'm reading what's left of your claim.
I've got a couple of different responses to that. Number one, the damages in this case are not just that his insurance policy is more expensive. That is certainly part
The
of,
reduction in property value.
Certainly the
and ability
reduction.
To sell the property in the future.
exactly, the fact that an identical
Of course, he can
property,
just not disclose all his history.
I'm sorry,
Of course, he can just not disclose the history.
although he would open himself up,
Yeah,
he would open himself up to liability if he did not disclose this in the
Right, right.
future. So he's going to have to disclose it if he wants to
Take
sell
a
the
page
property.
from the Smith's book.
Yeah.
And the Lynch's book.
An identically built house next door that doesn't have this problem is going to be worth significantly more. That's what some of the case law, Revitz included, talks about, is that the materiality of a condition is subjective based on how it affects the buyer and how it would have affected the buyer's choice to purchase the property. But I want to go back quickly to your question, which if you could remind me, it was about the damages, correct?
Yeah, I mean, just to the extent, insofar as you're seeking damages because of this debate between what you now have to pay for flood insurance versus what you thought you were going to have to pay going into it.
Okay.
Is there a case that kind of stands for that proposition that, hey, getting tagged with a higher insurance bill, yeah, that's material enough in and of itself?
Certainly, it's the Revitz case, in fact. I understand that that has a physical component, but
It
this is
definitely does.
this is certainly not just, this is a physical and a conceptual component in this case, because we've had 5 prior floods at the property,
Yeah.
which allows you to foresee what experiences you are going to have at the property.
You had a case where like the buyers looking around and saying, wow, all these other houses are built on stilts, why isn't this one?
Right, but I would
Oh,
also
it's fine,
point,
it's fine, nothing to worry about, it's still according to code. I mean, you can kind of conceptualize that a little bit easier under Johnson v. Davis.
I understand. I would say that there's not a single case out there that restrict Johnson versus Davis claims to only physical conditions, and that I've found in my
But, you know,
research.
I see Judge Lucas's point about, because I sort of felt the same way. And I think maybe by, you know, that's one of the reasons that the Lynches have tried to recharacterize your claim. Because you've relied on Johnson, so, okay, we'll make it about Johnson. You're not disclosing this is a flood area, but it's obviously a flood area. You're on the bay.
Right, but that's not what the allegation is. The allegation
No, I
is-
know,
Yeah.
but I wonder if by, bringing Johnson into this, you haven't sort of invited them to recharacterize your claim the way they have.
I disagree just to the extent that the condition, ignoring the fact that the property is located in a flood zone. It's flooded 5 prior times
No, I mean,
catastrophically.
I'm clear about what your claim is.
So,
But that's, I'm also agreeing with Judge Lucas that, meshing that with Johnson versus Davis is, it doesn't seem like a great fit.
yeah, I understand, but I would also say that under the seller's disclosure form, which was designed to help people comply with their Johnson versus Davis disclosure requirements, there's also requirements on there that you disclose if there's a lien on the property, if there's other conditions like lawsuits involved with the property that are not physical conditions of the property. So I think the idea is it's anything that materially affects the value of the property.
This undoubtedly materially.
Exactly.
affects the value of the property.
And I think the reason that we went to the seasonal flooding and the flood-prone area is because of this Nelson versus Weeks case. Also, if I could interrupt my own self, I wanted to reserve at least 2 minutes for rebuttal, so I don't.
2? Okay.
Yeah, so, or 2
All
or
right,
3.
you're good, you're at 11.
Okay, awesome, thank you. I think that the court improperly relied on Nelson versus Wiggs as if it was it's weird because it's as if it was a binding precedent, but interpreting it in a way that is not how it is supposed to be interpreted as well. Obviously, I provided the court of Nelson versus Wiggs to the court. And the trial court in this case said that pursuant to Nelson, a seller of a property is not required to disclose the flood-prone nature or seasonal flooding at a property that is in a flood zone, essentially. That's not what Nelson said at all. Nelson was a case-by-case analysis, as with all Johnson versus Davis cases, where the court was looking at, under the circumstances of Nelson, was the condition, which was the seasonal flooding, observable to the buyer, right? That was really the only question that the court in Nelson went into in depth. The facts of Nelson are completely distinguishable.
Well, that's not what you're talking about here.
Sorry?
And that's not what you're talking
Exactly.
about.
It's not even, I can understand why it seems related, because a property that flooded might be located in a flood-prone area. But whether the property has flooded or not has nothing to do with whether a location gets seasonal flooding, right? Lots of houses in Pinellas County are in flood zones. Most of them, I would say. A lot of them, I'm sure, haven't flooded. My house is not in a flood zone. It has flooded. So the point is, there's a distinction between seasonal flooding and disclosing 5 severe prior floods and a special insurance designation that makes it so that your property is worth substantially less than.
Was that a new requirement that the insurance companies will check out the rates recently based upon insurance requirements in the state of Florida?
As in, do they have to double check with FEMA whether it's a severe
Well,
repetitive
in other
loss?
words, but for the insurance increase, we wouldn't be here. That's the main contention that the buyers have.
No, that was the contention that he had before learning more information. When he was in pre-litigation, that was what caused him to start investigating further what he learned. We're here because the property.
You didn't have a current flood.
No, well, it's not in the record, but there has been one,
But
so.
it's not to be an act of God. You're limited to future potential losses based upon his increased premium. The premiums have gone up all over the country on waterfront property, and they have a Florida bar as is contract. How does that factor into the equation?
Because in this case, it's not just the insurance premium. Number one, he paid more for a property than he would have paid, or bought a property that he would not have bought if he had been told the truth. So there's the damage of he's overpaid for the property or bought something he wouldn't have bought. It's a significant investment.
But he wasn't told there was no prior flood history. He was told, we had a flood, we took care of it.
Right, and that's
And
the
there's 4
problem.
more prior to 1982 with different owners.
Sorry?
There was 4 more floods prior to 1982 under different owners.
I think it was between 1982 and 2020. I don't think it was prior.
Prior to the sale.
Yeah, so the thing about this is that it's a partial disclosure that minimizes not only the circumstances, but the damage as
Well,
well.
that's part of your argument too, right? That if this isn't really non-disclosure, they actually misrepresented.
Certainly, yeah,
And
and
that changes the dynamic in the analysis.
yes, so depending on, and that goes to the observability requirement. So whether the buyer could have observed the condition. The buyer has certain responsibilities to investigate things that they learn in a sale. However, if it's a fraudulent misrepresentation, there is no responsibility for the buyer to investigate the information. If If it's a negligent misrepresentation, they have to do ordinary diligence, so they liken it to a one-eyed horse. If you go to a horse show and you buy a horse, and you go home later and say, oh my gosh, the horse has one eye, I want my money back, you can't complain that you didn't see that the horse had one eye,
Right.
correct? So in this case with the house, I liken that to, if you go to a house, the windows aren't impact rated, you can see they're not impact rated, and then a week later you're like, man, I really wanted impact rated windows, I want out of this contract. That's something that any inspector can see. In the negligence circumstances, your diligence, essentially the case law tends to agree that if you've gotten your inspection and you've basically looked at the property, then that's sufficient. In addition, even if Mr. Smith was in any way negligent in trying to determine this information, the case law has suggested that that's not something that can get rid of his claim entirely. It's something that should be deducted from his damages from a comparative standpoint of his amount of negligence. And I can find the case on that if the court would like to see it. But in terms of the actual observability of this, I think we also provided significant evidence that only the homeowner can get this information, at least with respect to
Well,
the...
yeah, and the Lynches knew that.
Yes, and they knew that because of their conversations with Mr. Delacoste.
They knew the history, and they knew that the buyers couldn't get it.
Right, exactly. And they thought it important enough that they were concerned with getting the information, and they got a revised disclosure with that
I
document.
think they understood that it affected the value of the property because they didn't disclose it.
Right, and in terms of the 2020 flood, I understand that.
Well, if they'd asked us, we would have told them.
Exactly. So they've actually never, despite providing an affidavit in support of their motion for summary judgment, denied knowing these things. The attorney made passing comments at the motion for summary judgment hearing that there was a question of fact as to whether their agent relayed that information to them, but they didn't actually present any evidence of that, and that would also concede that there's a question of fact and summary judgment should have been granted. But the point is, they've never refuted that they actually knew, and in fact, they said that had Mr. Smith inquired further, they would have provided more information. I think the fact that it was important to the Lynches is hugely telling in the fact that would have been important to Mr. Smith. So I'm gonna reserve the rest of my time, but I just wanted...
3 minutes.
Oh, thank you. I just wanted to note, there's some really powerful language in the case law about the Johnson versus Davis cases. It says that the practical effect of Johnson is to encourage full disclosure in those transactions where a seller might be in doubt as to whether a set of facts should be revealed to a potential buyer. So in this case, considering it was a question to the Lynches, I believe it falls squarely within the type of information that should be revealed.
Thank you.
Thank you. You're so welcome. Also,
I'm challenged here. So I was going to start with the fact that this was a readily observable, diligent attention.
I want to stop you right there because one of the things that concerns me about your argument in this case is it really doesn't address what they're alleging. I mean, everybody knew it was a flood zone. Everybody knew it. They went, so that's not the issue. What's not readily observable is the flood history that the Lynches knew was only available to the property owner and kept to themselves. And I don't really see how you've addressed that.
Your Honor, I think there's two things I will say about that. One is about the 2020 flood, which was the one that happened when the Lynches were on the property. And I would like to quibble with the notion that they didn't make an adequate disclosure of that because they said, they characterized it, however, the exact words were, but it was about a $30,000 damage. And so my question about that is that I'm looking for, there it is, definition of slight. They said slight damage.
Here's what they said. They said 2020, they checked the box.
Yes.
They said, yes, there's past water intrusion. And under subsection G, they handwrite 2020 slight water damage to carpets. Water on garage floor, all was cleared and repaired.
Right.
Forget that last line, but the slight water damage to carpets, that is an understatement,
Yeah.
correct?
Your Honor, I don't know the extent myself of what the damage was. What I'm quibbling with is the characterization of it as being an inadequate disclosure that if Mr. Smith had said, well, what do you mean
You have to rip out drywall, if you have to remediate baseboards, if you have to take up everything from the ground up to 9 inches, that's not slight water damage to carpets.
Well, he certainly could have asked and they would have talked to him more about that flood.
No.
All right, well, let me go then to what you asked, Your Honor, more particularly.
Yeah,
the
what I
flood
just want to
history.
ask you is your position that a property owner selling their house who is well aware that it has a serious flood history, multiple floods over a period of years, they've gotten the flood history, is your position that there's no obligation to disclose that?
I don't think the record reflects that my clients were.
No. Let's assume they did know.
But we're just
So are you
assuming.
saying there's no obligation to disclose this flood history?
If in fact, the landowner, property owner, the sellers, if in fact the sellers had the past history in their possession, they remembered it from when they closed however many years before, they failed to disclose it intentionally, yeah, that could be a problem. But how about,
So why don't we have a fact issue?
well,
And
because,
also, what about the fraudulent inducement claim? I know I'm throwing a lot of questions at you, so answer however, in whatever order you want. I'm gonna be quiet for a minute.
okay, well, it's my job, so throw anything you want at me and I'll do the best I can. But I think that what the trial court focused on is what was the evidence presented to the trial court in forms of affidavits and otherwise. And our client did not, the buyer did not investigate the flood prone nature of this property. That was clear. He was told it was flood prone. The public record.
Well, you went to a flood insurance company and got an estimate.
Yeah, he sure did. That's right. And he could have inquired from them, is this gonna go up next year? Does this go up every year? How bad am I getting into this? Because
He could have gotten the flood history, could he?
he could have asked my clients, the Lynches, for the flood history or to get the flood history, especially if they didn't have it.
Clear one thing up. Was there a dispute or an acknowledgement that your clients actually knew the prior history, the 4 previous floods? Did they get the information from FEMA before the lawsuit began?
I don't know the answer to that, Your Honor,
They
because
had it before they purchased the house.
So
that's right.
Yes.
So they had all the information.
That's according to the seller who sold it to the Lynches.
Seller that's.
That he provided that
So the people
information.
that bought it from the Lynches could have done the same thing, but they didn't.
Right. That's true. And Mr. Smith could have asked them.
History, when you have it. They didn't know it'd be one thing, but they did know. They deliberately didn't tell them anything about the 4 previous floods, but only their own flood that they had.
If Mr. Smith had done just a minimal investigation, he would have found things in
Here's
the.
the problem with that, though.
Mhm.
To some degree, the Johnson v. Davis disclosures that have kind of come up and are required, the idea is that it's supposed to put the buyer in a position where they know things that the seller is aware of and that they can't necessarily get on their own. I don't really think there's a dispute that the seller was aware that this property had flooded in the past, in addition to 2020. My problem is that when you actively make a representation and says 2020 alone, not that there are 4 or 5 instances of flooding, just 2020 by itself, and then says it's just slight water intrusion on the carpet, that can be read as an affirmative representation. This is as far as it's gone, and
Yeah.
and I've signed this, and look, here's even a footnote that says Johnson v. Davis on the paper that I'm signing off on. Yeah, you're good. You can take that to the bank. That's a problem I'm struggling with, is that the actual disclosure that they gave may have been itself a misleading representation. Help me with that.
Well, Your Honor, I think that the evidence is lacking that my clients, that the Lynches had that knowledge still in their minds. And it was given to them when they bought the house, which was years before, or that they had a file somewhere where they could have dug it out of. What they got was the prior seller.
But to Judge Kelly's point, I mean, isn't that something that a jury should sort through?
Well,
Because this
we
gets
think,
resolved on summary judgment, right?
see, we think it's a little bit unnecessary here for a slightly different but very similar reason, which is that Mr. Smith's complaint was that he had to pay more for flood insurance. And he was damaged, as his language put it, $5,000 a year into the future every year. I don't know where that number came from, but other than the year, 2 months or so after the closing, that's what it went up to. But the point, I guess what I'm saying is that he was focusing on and claiming his damage was the increase in flood insurance and my client premiums. And my clients are saying, we're not guarantors of flood insurance premiums. Who knows what?
But he's also saying, I wouldn't have bought the house if I'd known this.
Well, he might have been saying that, but in the sale contract that he signed, there's a provision, disclosures, flood zone, elevation certificate, section 10D of the sale contract that specifically says if the property is in a, quote, special flood hazard area, close quote, then the buyer can walk away. Don't
Right.
get your money back.
Instead, he contacted a flood insurance company or an insurance agency and got a quote on flood insurance.
Right, so
Okay,
that's,
that's different than knowing this has the kind of flood history this house had, which then made FEMA give this designation, like 1% of houses have this designation. I mean, that's not, to me, that's materially different than knowing this is in a flood zone and getting a quote on flood insurance because, yeah, I know it's in a flood zone.
even the public record warned him. I'm not sure how much you have to warn a buyer before the buyer is responsible for his own actions.
Well, I want to go back to Judge Lucas's point, which is they disclosed that there was this, in 2020, there was this event and it was minor damage. And they make the point in their argument about, you know, if you say nothing, that's one thing, but if you make a misleading representation, that's a different thing.
Well, they disclosed a little more than that in the seller's disclosure. They disclosed there had been past or present water intrusion, past or present issues with drainage. There was flood insurance required on the property. They attached the elevation certificate, which put Mr. Smith on notice if he hadn't noticed yet.
I don't think there's any question they didn't know all that. But I guess, you know, I'm a broken record. I'm really hung up on the fact that the sellers knew about this property's history. And I think it's fair to say they misrepresented it in their disclosure. At a minimum, they didn't disclose it, but I think it's arguable that they misrepresented it. But I want to go back to a question I threw out at you with a bunch of others, which is I want to talk about the fraudulent inducement claim and why that was, what again is your basis for saying that that was proper for summary judgment?
Well, there was no evidence of fraud in the record that the trial court could have relied on to say that the Lynches, whatever they did or didn't do, had done it intentionally and fraudulently.
Intent is usually a factual issue.
Why isn't that a fact issue?
Well, because you have to have some evidence, don't you? I mean, you can't get to a jury or a judge on a trial without
We
some
know that when
evidence.
they bought the property, they had this information. And we know that they made this representation that there was a flood with minimal damage in 2020 and not, oh yeah, and there's this. I mean, why isn't that, you know, and the Smiths are saying we wouldn't have done it if we'd known this history. Why isn't that the guts of, a fraudulent inducement claim, and at least enough to get you to a jury.
I think what Mr. Smith said was, I wouldn't have bought the property if I knew my flood insurance premium was gonna go up. It's a different cast on the case than the court is seeing. He
Okay,
didn't
but
say,
that's
I don't want
That's
this
beside the
property.
point. I mean, you're not answering why that isn't enough, regardless of what he says he would have done. Okay, I wouldn't have bought it because my flood insurance, whatever, he wouldn't have bought it. Why isn't that enough to get the fraud, at least the fraudulent inducement claim in front of a jury?
Well, Your Honor, I think it's simply because there's no evidence that presented in that scenario that the Lynches did anything intentional. They gave him,
Well, again, you're back to intent, which I think we all, you know,
Here's the-
would
here's-
say, I don't want to beat you up, but I mean, that is traditionally a jury question.
And maybe he wins, maybe he loses. Maybe the jury buys that, you know, they believe that, yeah, no, they were unaware of this, they did the best they could with the information they had, plan to go hence without day, but to resolve this on summary judgment, on what sounds like your argument is that, well, there really wasn't enough there about intent on the fraud inducement claim, it's a little troubling.
well, I think we just heard one of the court is looking at it, and I know who wins that one, so. But I can't really give you any more of an answer than I have, that, you know, I'm going with what's in the record and how the case was cast at that time, and I think that's something important not to lose sight of. The complaint was, I get these higher premiums, and more
Well,
so.
and I can't recall looking at the pleading, but did they also seek diminution in value of the property, you know, diminution of resale? Or did it just say, you know, in the complaint, in the pleading, wherefore, as the beta between what we gotta pay on insurance versus what we're
Yeah,
getting?
I want to be very.
Or are you just kind of extrapolating it based upon negotiations and letters that come back, which are two different things?
I do want to be very candid with the court. I can't tell you
Okay.
if the complaint says what you're asking or it doesn't say that. But what I do know is, for example, Mr. Smith's affidavit in opposition to summary judgment, or maybe it's in support of both because they were competing motions, did not talk about that. It talked about the increased cost of the flood insurance premiums, and that if he had known it was going to get so expensive, then maybe he wouldn't have bought. Well, but the sellers aren't guarantors of that, and they had no way to know. And in fact, they didn't make any representations to Mr. Smith, which is Mr. Lynch's affidavit, about the cost of flood insurance. They certainly told him he was going to need it because they needed it, and he would need it to close. He did not avail himself of the opportunity to back out of the contract, which that provision I was reading, 10D, gave him when he found out that it was in a high-risk area. If he didn't find out, it was his own fault because it was right in the public records. The listing for this.
Wait, excuse me, what was in the public record?
The fact that this property is in a high risk for flooding area. This is, I'll tell you where.
Are you referring to the AE designation?
The AE designation and just a little bit more in the listing for this property in Realtor.com, which is online. You could have picked, you know, searched it and got it. It was attached to a motion for sanctions that's in the record in Composite Exhibit A to a motion for sanctions. The Realtor.com listing says the home is located in a FEMA flood zone AE, quote, within special flood hazard area and indicates high risk, close quote.
Isn't that generic though to just any AE designation, or is that?
But there's some more. I'll read you the rest.
Okay, go ahead.
The home is flood factor 10, which I assume is the worst. I don't really know, frankly. And, quote, flood risk is increasing as sea levels rise and weather patterns change. I mean, to me, just that listing,
No, that's not true.
that sea levels are rising.
Yeah. Sorry, that was an editorial comment.
Well, I guess my point about all that is that if he had even just done the minimal Google, I mean, everybody knows how to Google search, right? and read that, wouldn't that make a reasonable person say, I should really better find out more about this flood insurance issue that I'm worried over? He had an agent, he had a real estate agent as well, but he had an insurance agent, and he had an inspection done of the property, and after all of that, he said, I'm waiving, my inspection period, and I'm gonna buy the house, and he closed. So we think that the trial judge was right, because when you take all the facts and you put them all together, the nature of the property was easily accessible and obvious, and the fact that premiums go up is certainly not on the seller. So we think the trial court got it right and should be affirmed. Thank you.
Thank you. All right, we've got 10 minutes.
Thank you. Keep it very brief.
Let me have you pick up
Sure.
where Ms. Tomasi left off, which is, actually, there was a lot of information out there that might have set off an alarm bell in Mr. Smith's head that I better investigate further. And, I mean, the Lynch's thought to do that. Would you respond to that?
Certainly.
Especially, things like she said, you can Google, there's plenty of, even if you can't get the flood history. Wasn't there enough there that maybe he should have investigated further?
So a couple things. The Lynches did exactly what Mr. Smith did. The only thing is that they had the benefit of getting the insurance policy assigned to them, so they were provided the information that they wouldn't have had otherwise, because Mr. Smith's, there's no evidence that Mr. Smith's insurance agent knew about the special FEMA designation. The reason the Lynch's agent knew about that is because they just took over Mr. Delacosta's policy, right? All they did, exactly, all they did was say, actually, they did even less than Mr. Smith, because they didn't even go looking for their own insurance, they just had the policy assigned to them. Mr. Smith is told, property's in a flood zone, it's flooded once, it was slight. Mr. Smith gets an inspection, he did not waive the inspection period, he gets an inspection, and then the inspector says, house looks fine to me. He moves forward, he gets an insurance quote, he says, well, I've never paid for flood insurance before, but this looks reasonable. I'm gonna move forward. He's done his due diligence. And I think instead of talking about what each person subjectively did, I think it's important to come back to what Johnson says we have to do, which is a buyer has to have ordinary diligence in discovering information if it's a negligent misrepresentation. It's
I have a question, because you said that the existing flood policy was assigned,
to the Lynches.
which I've never heard, because every time I'm familiar with an insurance company, they say, we don't assign policies, get your own policy. Are you saying they assigned it?
Yes.
Almost like there's a conspiracy here?
No, it's my understanding that because of the fact that,
The Lynch's had the policy assigned from when they voted.
yes, and because it was a
Not your
special,
client.
exactly. So the Lynches had the prior owner's policy assigned to
I've never
them.
heard of that happening for maybe 20
And
years.
usually they say no.
Right, but this is a special policy. So we've provided in the record, there's, I can't remember what document it's in, but I can certainly look.
They gave the benefit of the lower rate.
It's not a lower rate, it's, you can only insure one of these severe repetitive loss properties with one type of insurance, and that's the citizen-specific insurance
The
that,
Lynch had this special policy.
yes, and that's why it was able to be assigned, is my understanding.
And your client knew they had a special policy?
No. So let's take a step back.
Yeah,
So
go ahead.
the Lynches buy the property from Mr. Delacosta. This is far before Mr. Smith is involved, right? The Lynches find out this information when they get the insurance policy assigned to them, because the insurance, it's the same policy, they've got it noted that it's a severe repetitive loss. They then buy the property subject to that knowledge. A couple years later, they sell the property on to Mr. Smith, who's unrelated to this transaction, and they don't assign the policy. He just gets a quote for his own policy and isn't advised of the special flood hazard or the insurance or the
He
history.
had his own policy, his agent didn't tell him?
No, because it's not a matter of public record. In fact, it's federally protected information.
Yeah, no, so no, if the agent did some more due diligence, and hey, I just found out, and by then they had to close it.
My understanding is, based on what the insurance agent from Mr. Smith told him after they discovered it, is that it can only be discovered in underwriting after the fact. So
Well,
that's
a
exactly.
question of fact. Maybe-
Okay,
Maybe there's more.
I'll let you answer Judge Blinken's question, but then you need to around.
Okay, no problem, thank
I
you.
understand.
Okay,
We've used your time.
okay, so I'm just one thing, and it's the Florida Supreme Court's, statement in Gilchrist that just says the law appears to be working towards the ultimate conclusion that full disclosure of material facts must be made whenever elementary fair conduct demands it. And I think in this case, given the Lynch's knowledge, elementary fair conduct would have been to provide Mr. Smith the same information. Thank you.
Okay, thank you both. All right, all right, we're gonna take our next case, Corbin versus McDaniel.
Thank you.
Morning.
Whenever you're ready.
Thank you, Your Honor. May it please the court, my name is Drew Corbin, and I'm here on behalf of the appellant, Drew Corbin, who also happens to be my mother. This is a simple case. This is a simple case. This is a landlord-tenant dispute. The fact of the matter is there's a signed, handwritten agreement between the parties that they've been performing on for the last 5 years. For the last 5 years, every month, my mother has gone to the landlord's lanai and dropped off either a check or cash payment to secure her use of the property on 34404 Lock Road, Charbon Springs, Florida, for a horse stables. She trains and takes care of horses, and she's done it for the last 14 years. She staked her entire business on the performance and
Well,
execution.
before you go into too much detail about that, I don't think anyone's disputing she sounds like a lovely tenant. Took care of animals, horses, and did a great job. But you have a 50-year lease that you're seeking to enforce. I haven't seen a 50-year lease since World War II. Number one. Number two, there was a 90-day escape clause. Either side can get out of that 50-year lease by giving 90 days notice. So the judge found in favor of your landlord. The judge said, hey, I don't think the lease is valid on space, which is the opposite position from what you're taking. But if it wasn't, I find there was sufficient notice. Is that correct?
That's not correct, Your Honor.
I mean, that was in a judgment.
It wasn't a judgment, Your Honor.
That's all my question. Was it correctly, what I said, was that in the judgment, whether you agree or disagree with the judgment? That was in the judgment.
Yes, it was, Your Honor.
Okay, your turn.
To address those points, Your Honor, with respect to the 50-year term of the lease, it could be a 100-year term, it could be a 200-year term. It doesn't matter. The fact of the matter is they performed on the agreement. The complaint from the landlord alleged one thing, that the signed handwritten agreement was not valid pursuant to the statute of frauds. The statute of frauds is a relatively new legal doctrine, and all it is a doctrine designed to eliminate fraud. That's it. That's the only thing it does. The only thing it does is to eliminate documents that are literally fabricated. They're literally not what they purport to be. So the moment the landlord filed a complaint and alleged that this signed handwritten lease agreement that they've been performing on for the last 5 years was invalid pursuant to the statute of frauds, they themselves have committed fraud. Because they're saying to the court, this agreement that we agreed to, we were offered, we accepted, we've
Your
been
religion is partial performance, and that should take out of the statute of frauds anyway.
immediately, because if we don't do that, then we live in a world where anybody can just go and make offers, start performing on them, and then go to court and say, oh, there weren't 2 witnesses. We don't need witnesses. The parties have witnessed the agreement themselves. It's self-authenticating.
Who prepared the lease? Buyer or the lessee or the lessor?
The lease was prepared by the tenant, my mother, but the fact remains that the lease was dropped off at the landlord's house, where it was likely considered for a number of days, and then both parties met in the landlord's lanai reviewed the document together, and made changes to the document together, and then signed it. So to the extent that the landlord wants to say this phrase, 90-day notice, any changes, should be read to allow the agreement to be terminated, there's a couple issues with that. The one is her own deposition testimony, where she admits we never operated according to a 90-day notice provision, 90-day change provision. The second is the language of the document itself. Right before 90-day notice any changes, it says the term, 50 years. So the fact that it then says 90-day notice any changes, it must be read to not be in conflict with that previous term. And we can read it so that it's not in conflict with the previous term. We just read it to say that it's with respect to the preceding terms. There's no punctuation after it, and it only applies to those terms. If we read it to say that, we can.
Now, your client voluntarily left the property after the writ of possession was issued? She's not there now, correct?
That's correct, but my client did not leave the property until after the writ of possession was issued.
And you had a problem with the writ of possession because the clerk didn't issue it, the judge apparently did it by judgment.
Yes, the judge issued it.
There's no rule saying the clerk. The judge can do it, the rule says the clerk is the one who should do it.
I'm not aware of that, Your Honor.
I guess I'm trying to find out. I think the clerk should have just done the possession automatically. Maybe it was done. I don't think it's part of the record. But the judgment seems to award possession, and the judge didn't worry about the clerk doing it or not doing it. Does that pose a problem for you?
I hope it does, Your Honor. I was not aware of that specific issue. I hope it does, but I'm not aware of that.
Might a little bit higher.
I'm not aware of that specific issue. I do know that
I thought that was part of the issue you guys were arguing over. If you're not, just keep going.
No, I look at this case very simply, and I say there's a signed handwritten agreement that's been performed on for the last 5 years. The only allegation in the landlord's complaint is that the agreement is invalid pursuant to the statute of frauds.
So under your reading, what does the 90 days, any changes, what does it, ma'am, please don't make hand gestures, thank you. What does the 90 days, any changes mean?
To me, it's very clear what it means. It means that there were 90 days to make any changes to the terms that precede the phrase. And we know that's true by the landlord's own deposition testimony, where she says, we didn't make any changes within 90 days. So she's admitting that's the right that we had. And then we look at her actions. She didn't give 90 days notice.
But I thought the leasehold term actually preceded the any changes 90 days. So by that argument, that means that the 90 days, any changes could potentially terminate the 50-year lease, which isn't unreasonable because, as Judge Valenti pointed out, 50-year commercial leasehold is uncommonly long. But it's almost a fee.
Let me take the flip side of that. So we got to look at it from the tenant's perspective. Is the tenant going to agree to this lease where she's trying to secure a long-term arrangement on this property because she's got senior horses that are at risk of losing their lives if literally they're just moved from the property because they're 30 years old, which is old for a horse. She's trying to secure a long-term arrangement. She's not going to agree to something that allows her to be terminated in 90 days. And the landlord didn't even have the authority to act upon that provision because the landlord didn't approach the trial court on a basis of breach. The landlord didn't allege that they had the right to change the agreement within 90 days. The landlord approached the court and said, here's this signed handwritten agreement that I've been performing on for the last 5 years. It's invalid because it's not evidenced by 2 witnesses. And the moment the landlord did that, they committed fraud. So as far as the 90-day notice changes, it can't mean what the landlord now wants it to mean.
Okay, well then help me out. What does it mean? Because it was a negotiated term, it got written in there. So what is it? 90 days any changes to the monthly rent? That doesn't seem likely. 90 days changes to the scope of the number of stalls? That doesn't seem, so what does it mean?
What it means, Your Honor, is that each party had 90 days to make any changes to the terms that precede the phrase, or that follow the phrase. And the reason why they did that is because...
So in theory, let's say it's not a termination, in theory, by your reading of that argument, you're saying within 90 days notice we want to change this from a 50-year lease to a 1-year lease.
Only within the 90 days from the time that they signed the agreement.
See, now you're adding more on to...
That's the reason why that is it's very clear from the document and then very clear from the facts of the case. the parties didn't know all of the terms that were,
I mean, help me out here on that, because then what you're saying is, okay, we're agreeing to everything, but within 90 days, we can change anything, which sounds like, and then what you got is basically an agreement to agree. I mean, you don't have to finalize the contract. Any second is 90 days notice, we can change anything in the preceding agreement, anything, on 90 days notice. You don't really have a contract.
well, you do, because when a party goes to another party and says, here's a lease to lease my property for 50 years, you can make changes to this document within 90 days, and then that 90 days passes without there being any changes, it's set in stone. And the reason the parties did that is because they wanted flexibility. They didn't know all of the things that were going to come up in their lease agreement. So they put this phrase in there as a way of giving them a window of time, and we know that's what it means, and we cannot allow the landlord to prevail on a theory that was not alleged in their complaint, and that they actually did not obtain the legal authority to act upon it. What I mean by that is simply 90 days notice was never given. So how could they argue that we have the right to terminate this lease upon 90 days notice when they never actually gave 90 days notice to the tenant? The landlord wants to say, oh, they really had 90 days notice because 90 days have passed since the letter was given. Well, the letter was only a 30 days notice, and you certainly didn't wait 90 days till filing a lawsuit to get us off the property. So I think when the trial court looks at that evidence, they have to draw the conclusion that this phrase doesn't provide a notice of termination, right? Not when there's a clear terms.
Well, let's go back to basics. Who was leasing the property? Was the husband supposed to be on the lease, the lessee's husband? Because the trial court said he didn't sign it, so it wasn't enforceable.
Yes, Your Honor. That was another issue that the trial court had with the lease, is that the landlord's husband was not a signatory to the lease, and he also owns the property. But it was error for the court to do that analysis because they're only looking at the landlord's consent or agreement to the lease from a subject.
My question is, was Gene McDaniel's name on the property, on the paperwork where he should have signed it, where his name was printed? The trial court also said there wasn't witnesses, that would prevent recording, obviously, but was Gene McDaniel's name typed anywhere on the lease?
No, it was not, Your Honor, but
they expected him to sign it.
they didn't expect him to sign it, but when we consider whether an agreement was agreed to, we look at it in objective standard from the other party's position. And from the tenant's position, my mother, there was no way a reasonable person in her position would construe the landlord's actions and the actions of her husband as anything other than full assent to the terms of the deal. And the reason that is because the wife signed it in the lanai of the house where they both reside, and then the landlord and her husband performed on it for the next 5 years. So the landlord and her husband are out on the property, allowing the tenant to go out there.
What about the lessee? Why is the husband out there also?
He lives on the property, he lives there just as much as the landlord, and he's out there performing on the lease just as much as the landlord is because he's accepting rental payments.
2 people leasing, 2 people signing the lease.
One person leasing, the tenant, my mother, 2 landlords alleged, but really both are performing on the agreement. So to the extent the landlord wants to allege this is an invalid agreement
How
because
many people sign the lease? Let's just break it. One
2
person,
people signed the lease, but 1 landlord.
one landlord, one landlady. And how many people own the property?
2.
2 people own the property and 1 person signs the lease.
That's correct.
And that's why the judge said it's not a binding lease. You don't have both owners.
That's correct, Your Honor. But
I'm just saying, that's what it looks like on that issue.
right, we find error with that, and the reason why is because the husband's consent to the lease is not a requirement for him to be a party to the lease. What's required is that he objectively perform on the lease,
Well,
and that's what he did. He accepted rental payments for the last 5 years. He allowed the tenant to go out onto the property. He never objected.
do you account for reformation to say only 1 person needs to sign this? I mean, if someone's leasing my property, I need to sign it, I've got something to say about that.
Right, and if your spouse leased your property to somebody else and that somebody kept going onto your property for 5 years, that somebody would be reasonable to expect that you were also agreeing to that, to agreeing to what your spouse had signed.
You're talking legalese now, or you're talking reality? Because reality, you're right. Reality is the thing, you didn't sign it too bad, but now there's a problem.
Well, I think the legalese matches the reality because the legalese requires there to be objective performance. Again, the husband, Gene, could have not known about the lease agreement at all. He could have subjectively been, totally against it with his wife and said, why are we still doing this? Why are we still doing this? It doesn't matter because objectively he's performing on the agreement. Objectively, he's accepting rental payments from the tenant.
Okay, you keep talking about objectively, tie that to a defense or a legal claim that you asserted.
So,
Was there, Judge Linton mentioned reformation, was there an estoppel claim, was there an estoppel defense, was there implied contract that it should be implied that he's a party to this contract, such as your story?
our defense and our answer was that the agreement had been partially performed, and that was all that we would have been required to allege based on the allegations in the complaint, because the only thing the complaint alleged was, here's this handwritten agreement that we've been performing on, and it's not valid pursuant to the statute of frauds. So we say, well, yes, it is, we've been performing on it. And then they go and say, oh, well, actually, my husband didn't consent, actually, we have a 90-day notice termination provision. As soon as the landlord says this agreement is invalid because my husband doesn't consent, she's basically admitting that she's committed fraud on her husband for the last 5 years.
You've said that like 3 or 4 times and mentioned it numerous times in your brief. I get it. I'm really trying to focus this on tying this to an actual claim that was asserted by either party and that was adjudicated by the court.
Right, okay, so let me take that. So to that point, I mean, we're not going to make any claim in our answer with respect to the idea that Gene, the husband, is not performing on the agreement because it wasn't alleged in the complaint. But as soon as it's alleged, it's a very simple legal argument to say, of course he's a party to the agreement, he's been performing on it for the last 5 years. It doesn't matter that he didn't sign the agreement. The fact of the matter is, he's accepted lease payments for the last 5 years, he's allowed the tenant to be on the property for the last 5 years. No reasonable person in the tenant's position could construe that. What's the
But they tie that to a legal theory, though. I mean, I hear what you're saying. You're making the arguments really well, but tie that to what legal theory is that tied to that binds a non-signatory to a lease agreement, contract? What binds that non-signatory to? What legal claim? What ship are you sailing?
Yeah, it's part of performance. That's what it is. She's the husband, the landlord has.
So it's an implied contract. Is that what because part performance only matters in a contract theory claim.
I don't think it's implied. I think it's the very agreement that's at issue in this dispute. Again, the tenant knows that the landlord signed this agreement. The tenant knows that the landlord's husband is performing on the agreement. So the landlord.
Let me make this easier, okay? Because I'm not doing a good job conveying what my concern is. My concern is, let me give you a hypo. All right, my wife enters into an agreement of some sort where she agrees to provide website hosting services or website design services, and she's performing on that agreement in my house, and she does it for years for a client. The client's not happy. The client sues her, and the argument is made is, hey, Matt Lucas he's aware of that agreement. He's a signatory to that as well. She's been performing all the time in his house, in the house that they share. How am I now a signatory to that contract? That's the concern that I have.
You're not a signatory, but you've performed on the agreement objectively, and so you'd be.
So you would say I would be liable on that?
I think you would, because you're indicating to the other party that you are performing on it, and no reasonable person in that position would construe your actions.
I'm doing nothing but sharing my house with my wife in this scenario.
Right, as when your wife is also a signatory to the agreement. And look, the facts are.
Sorry, I just want to let you know you're at the 5-minute.
Okay.
Use your time however you
Thank
want.
you.
If
If
you
I
want to
may,
say something for
could I reserve 3 minutes for rebuttal, and I'll just.
Yeah.
So, look, to your point, those facts are even worse here, and here's why. Because the landlord's husband has been performing on it from even before when they signed. The facts establish that the landlord's husband was out with the tenant and the landlord reviewing the property, okay, with the tenant's clients. So the tenant's out there with her clients, with the landlord and the landlord's husband, looking at the property to determine its viability for whether she can operate her business on it. How is a reasonable person in her position supposed to think that he's not agreeing to this agreement when his wife goes and signs the agreement in their house and then performs on it for the next 5 years? He would have had to almost immediately, gone to the tenant and said, I don't agree with this. I don't know what you signed. I don't know why you're here, but I don't agree with this. If he doesn't do that, if he's silent, then he starts to indicate to the tenant I'm agreeing to this objectively. No reasonable person could think otherwise, because you have a husband and a wife that are performing on an agreement. The wife signs it. The husband was there before the negotiations. He's there after.
Attorney, what are you saying? She didn't have a power of attorney to sign for his behalf. His name is not on the lease.
Maybe all he was agreeing to was just a month-to-month kind of deal, like, let's see how it works. Maybe that's all he's agreeing to.
But that's not the law, Your Honor. It doesn't matter what he was so.
This is the one-page lease.
That's
This
right.
is ripped out of a notebook. It's a holographic lease. I haven't seen anything that crazy looking in the law, not to be deferential, but usually it's a 40-page lease for a thing that long. And usually 5 or 10-year increments. You just don't have a 50-year lease and claim that's valid and enforceable. So I can understand where the judge was coming from. Judge probably never saw one like that either.
Courts have upheld oral agreements under similar circumstances, not just written agreements. It's not the vehicle by which the agreement is conveyed, it's whether the parties actually agree to it, and there's no way. Of course there is.
If holding up the property doesn't mean I sub the lease, and I understand it thoroughly. There's no ambiguities, and I agree to everything in there.
Right, so maybe there's not evidence that he subjectively agreed to it in his mind, but that's not the law. The law is whether a reasonable person in the tenant's shoes would construe his actions
So
as.
you had an actual trial, and the judge said there's no valid lease and other things.
Well, we're here on.
I'm not sure what the argument is that the judge got it wrong.
The judge got it wrong, Your Honor. We're here on competing motions for summary judgment. The judge is saying this lease agreement isn't valid because the landlord's husband didn't consent. That's not even the law, whether the landlord's husband consented to it. The law is whether his actions would indicate to a reasonable person in the tenant's position that he was agreeing. And again, when we look at, he's there looking at the property with the tenant, he's there allowing the tenant onto his property for 5 years.
Under your theory, no one has to ever sign a lease. They can just occupy it and say, we have an agreement verbally, and it's binding. And we partly performed it and paid for 5 years.
I think it's a factual scenario, right? It's dependent on the facts. But as time starts to go on, maybe instantly, because there were case law that was cited where, hey, my husband didn't agree to this, my wife didn't agree to this, she wasn't in the room. All of those cases were challenged instantly, within a matter of weeks that they didn't agree to it. Here, this is different. We have the husband saying, I didn't consent to this 5 years later. So we have 5 years of objective performance on the signed handwritten lease agreement, including him accepting the rental payments for 5 years. And then,
Sorry, you need to wrap up. You're at the end of your 20 minutes.
if I could just make one more point.
No, you need to wrap up.
Okay.
You've had 20 minutes.
Thank you.
All right, sir.
Good morning, and may it please the court. My name is Avery Chapman. Fun fact, I'm founder of the Florida Bar's Equine Law Committee. I'm glad to hear the word horse in another case. We're always happy when horses intersect with the law. I think what Judge Valente was getting at was honing down on the Murray v. Sullivan case, which was cited at Record 99 in the motion for summary judgment, and I think was part of what the judge relied on. I know we're here on Mr. Corbin for his client appealing the writ of possession, but it seems that the writ of possession was based upon the findings under the MSJ. Under the Murray v. Sullivan case, the idea was, well, before you can have an exception for a missing tenant by the entirety, for a lease, let's say, or encumbrance of a property held by a husband and wife, you have to have clear and convincing evidence that the transfer does not, one, adversely affect the interest of the other spouse, and two, is done with the full knowledge and assent and acquiescence of such spouse. That's, I think, what's behind the questions, and that's a question of pragmatics here. And I know the court has been concerned with that. Our response to that, which is reflected in the record, is Gene McDaniel testified unrebutted that his wife didn't tell him about a written lease of 50 years or of any term. He assumed that Miss Corbin was there under a month-to-month non-terminable at any time type of tenancy. He
Is that in
didn't,
the record, did that come out in the summary judgment, or how do we know that?
you will see that in the record that's filed with the court, but it came out in numerous places. I can actually give you the record pin sites if you'd like. You tell me, I'm happy to pull them out.
They have is this thing.
Yeah, okay. Let me do that for you. Jean testified, and if you look at record 99, it's set forth in the brief, which kind of gives you the pin sites to the depositions. But Jean testified throughout his deposition, pages 69, 82, 83, 83, 84.
Is this of the record or the depo?
I'm going to get you the corresponding one right now. Here we are. I'll get it to you in just a second because I don't want to waste some time. It's all part of the record there that Jean testified and Diane testified as well in her deposition, also part of the record, that she never told anybody. She had forgotten about the written lease. She didn't tell Jean, and that Trudy Corbin took the lease with her once it was signed and never received a copy. So she didn't even think about it. So what does that leave you with? I'll get you those citations just a second. That leaves you with a gentleman who's attended by the entirety. Ms. Corbin testified she knew they were married when the property was purchased, who did not know of some 50-year lease, basically a fee type arrangement, would never have consented to it. It was also testified in the record that they were in their 50s. A 50-year lease would have been lifetime for them and would have for their children for whom they purchased the property, also part of the record testimony, would have put the children subject to Ms. Corbin's lease until the children were in their 60s. So Jean testified, I never would have agreed to such a lease, and of course I didn't. I understood she was there. So that's what the Murray v. Sullivan and its progeny in those cases are, I think, where the judge was getting to when he asked that question.
What about Mr. Corbin's argument that, hey, that may very well be, but that's not the flag you flew on your pleading? I don't know that there's a pleading objection made to the motion for summary judgment. It's
Sure.
kind of over that a lot.
First of all, Mr. Corbin, that very argument, I'll address it and I'll answer it. But Mr. Corbin himself did not raise that argument on appeal. Okay. But to answer your question, the judge, and again, this is a little tricky because there's a motion for summary judgment ruling, then there's a writ. In the motion for summary judgment ruling, about a month prior to the writ, maybe a little more, the judge said, look, I find several things. I find one, the lease was invalid because it missed the two subscribing witnesses, which was required under the 2018 version of the statute, and because Jean's signature is missing. Then I also find...
Okay, that's the
Right.
order. I'm asking about the pleading.
Right.
Pleading
Right.
precedes the motion and the order.
So-
what was the pleading?
So we pleaded, at the time, we pleaded the missing two subscribing witnesses. Okay? What was essentially tried by consent through the motions for summary judgment was the issue, because this thing was scheduled for trial like the next week.
Yeah.
But what was tried by consent through the motions for summary judgment and was fully briefed by both sides was the issue of
Lack of a subscriber.
Lack of-
Lack of a co-owner.
co-owner. Okay, that was briefed both ways. There were
On
motions. Yeah, motions and cross motions. So it was essentially tried by consent, would be my argument. And briefed by consent and addressed, and Mr. Corbin had the opportunity to rebut that. However, he did, and he did file a reply brief to our cross motion. So he had the opportunity and engaged in that. So that's my response to that. I'm pleased to answer any other questions. Of course, I had a full set argument, but I'm sensing from the court's inquiries that you had specific points. If not, I can certainly, in the time I have, dive into that. You tell me, and I'll proceed either way.
Any questions?
No questions here. Thank you.
Okay, so I'm just going to make a couple, pinpoint a couple points real briefly then, if there weren't any specific questions. Again, I think it's important to understand that this was sort of like a decision tree type of result. It was, okay, again, let's look at the face of the handwritten lease prepared by the lessee. The judge found, under summary judgment, that there were some issues with it, well, I'll say technically or statutorily. Missing subscribing witnesses under the 2018 statute, missing Jean Daniel, the tenancy by the entirety signature. But if, and it says alternatively, or alternately, in the MSJ order, if it's valid, it still is terminable upon 90 days. I apply the plain meaning of the statute, plain meaning of the language there. 90 days does not mean something like 90 days only to terminate. It doesn't mean anything like that. It's very clear. It's a 90-day notice, any changes. Change can be termination. Judge Lucas raised the point that could have changed the contract to be a one-year term. By the way, you raised something about agreement to agree. I actually briefed that in our appeal brief response. That was an issue of an illusory contract. That if you could change anything in a contract, then basically you have and I will if I want to argument, which is another way illusory contracts have been phrased. And our position was, well, then alternately the contract was an illusory contract, even if the court didn't find. So that was how we got to where we were. The writ of possession, emergency writ, was issued after Diane Corbin put in an affidavit at record, it's either 1095 or 1118, where she said, look, there's fires going on, there's people there with liability waivers, there's business being conducted, there's all sorts of things that aren't good there happening, this is dangerous. So the judge had her own reasons to issue the writ, independent of finding the lease to be invalid. So I think that's important to note. At this point, from a pragmatic standpoint, we had a lease. The theories were tested by Mr. Corbin. They were fully heard by the judge. They were fully briefed. Any issue that wasn't raised in the pleading was then tried by consent. 1 second, please. Thank you. I have nothing further. If the court has any questions.
All right, that concludes our docket for today. You used your 20 minutes. I'm sorry, sir.
That's okay. Thank you.
I tried to let you know. All right, thank you
All right.
both.
Listen, you got lucky. You got to go for the DCA early in your practice. That's a good thing.
Yeah. You here often?
Not this DCA now, because I'm off on the other side. But anytime you get fellow experience, I think it's good.
What, are we supposed to become friends?
What?
Are we supposed to become friends or something like that?
Colleagues.
College?
Colleagues.
Because I think we're starting to get a lot of cases together.
I don't know. You know, I mean, I think that the thing about professionalism is cases are cases. Attorneys should always be civil and professional.
No, I agree.
Right? You get a lot more, you can catch a lot more bees with honey than with a shotgun.
Yeah,
All
definitely.
right?